Thank you, Steve. I think it may be possible for I'm gonna answer all 8, but I think at least a couple of them may overlap with one another. So it may be that I can economize a little bit. As to point 1, I want to be very clear about something, and this is something that distinguishes me. I don't know how many habeas geeks there are other than Steve and me in the room. As you can see, at least 2. So some of this gets a little involved. But the response to Steve's first point is a point on which my position is not the same as that of David Shapiro and Amanda Tyler. We all agree on the fundamental point that a suspension is an expansion of substantive detention authority. It's not primarily a limitation on the judicial remedy. That's the huge big thing. Amanda and David Tyler believe that the suspension clause either is or is an indicator of a grant of a power to suspend habeas corpus. And Steve asks, if that's so, what's it doing in Article 1, Section 9? My view is that's not true. The grants of congressional power to restrict natural liberty appear where the bulk of the grants of congressional power appear, in Article 1, Section 8. And in particular, the ones that are most important are aspects of the war power. Congress's power to declare war is the power to change people's substantive rights for national security reasons, to authorize, for example, holding people as prisoners of war, which is to say, restricting their natural liberty. There's also an implied congressional power to put down rebellions. We know it's implied because there are a couple places where the Constitution alludes to it without creating it. But there are substantive powers, my view is there are substantive national security powers that authorize executive detention, that authorize the authorization of executive detention, and the suspension clause limits them. It says one particular form of authorization can be had only when there's been a rebellion or an invasion. And that leads to the answer to question number 2, which is, does this reading of the suspension clause drain it of force, mean that Congress can get around it? No. Because the premise is that the suspension clause is directed at something that is relatively focused, but in the view of the framers, and I think a lot of people today, really, really bad. And that is the grant of discretion to the executive. That national security detention is obviously very problematic. Anything other, detention for people for any reasons other than criminal conviction is a real problem in a liberal system. But a lot of people in the 18th century, and again, as I say, plenty of them in the 21st, think that it's really bad, especially this is one perhaps side effect of for those of us who believe in a unitary executive, to give a single individual that much power is a real problem. And so it's true, Congress can get around it by imposing legal restrictions on whom the president can detain. But by doing that, Congress isn't getting around it, they're complying with it. They are providing what the clause is designed to provide, which is law-like constraint on executive discretion. Which is, and this is the first point of overlap, that will be my answer to the question, what about the debates of the habeas corpus suspension clause when they thought it was really important? Well, what they thought was really important was not to have their liberty in the power of a single individual. And that comes out again in the debates over the proposed suspension for the Aaron Burr conspiracy. I think I took out the footnote, or maybe I left it in, that mentions that one of the people who seemed most concerned about granting a lot of discretion to President Jefferson, one of the members of the House of Representatives, was Jefferson's son-in-law. I have no idea what he knew about my university's founder that might lead him to think that the man should not be allowed to have untrammeled discretion. But he certainly was concerned about that. Steve, remind me what point 4 was?
So if the suspension clause doesn't govern the remedy, what does?
Oh, I'm sorry, yes. If the suspension clause doesn't govern the remedy, what does? Other constitutional principles. And as to federal habeas, but I will now tell you what they are. Don't worry, I'm not just gonna leave that sitting there. What did you think was going to be the answer? But there is an answer. As to federal habeas corpus, what governs it is Article 3, which includes the Madisonian Compromise, pursuant to which lower federal courts are not mandatory, and the original jurisdiction of the Supreme Court is, for those of us who think that Marbury against Madison was correct on this point, is necessarily constitutionally not at all is quite limited, meaning there is very little constitutionally mandatory original jurisdiction in the federal courts, meaning Congress has a whole lot of authority to decide whether or not to give habeas corpus jurisdiction to the federal courts, and that's how it answers that question. Is that worrisome? Well, you might think so. I don't think so, but that's because my answer to the second part of the question is there are, of course, the state courts, and this is the concluding point of Henry Hart's famous dialogue about who ultimately enforces the Constitution. What about Congress's power over the jurisdiction of the federal courts? Well, Congress has more limited power over the jurisdiction of the state courts than it does of the federal courts, and indeed, I take a position that's even more restrictive of congressional power with respect to the state courts than that of a lot of people. So I think that it leaves natural liberty just where Henry Hart said it leaves most constitutional interest, which is primarily protected by the state courts in ways that Congress has only limited authority to override, and protected by the federal courts to the extent that Congress and the Constitution together through Article 3 create jurisdiction in the federal courts. 5, what about the importance, as Paul Halliday stresses it, of the common law writ as opposed to the statutory writ? As I say that suspension can be the term probably evolved from suspension of the Habeas Corpus Act. What about the fact, and this is another one of these excellent habeas geek inside baseball things, but it is quite interesting. A large part of the burden of what Paul Halliday says in his excellent book is don't believe the story that says habeas corpus is about Parliament protecting people's natural liberty against the king. Parliament didn't like the natural liberty of people it didn't like any more than the king liked the natural liberty of people he didn't like. It's about the judges. And one of the technical ways in which that comes out is the continuing robustness of the common law writ of habeas corpus as opposed to the writ of habeas corpus under the Habeas Corpus Act. My answer to that is that's all true, but it is about the remedy, and it's not about the right. That the right was the same for both the common law writ and the statutory writ. So as far as I'm concerned, anything said about the Act may just as well apply to the common law. I think that also provides the answer to question number 6, which is also about what Paul Halliday said, again, about the great importance of the judges before 1777. Absolutely true, but fundamentally about the remedial question. I don't mean to suggest that the remedy isn't important. It's an important part of habeas law, but it's not a really important part of the suspension clause. And so just true, but not really to the point. Do I think that the habeas corpus suspension clause compels the state courts? No. I don't think it compels them to do anything. The situations in which the state courts may be required, as Steve says, by certain, at least contemporary Supreme Court doctrine, to give constitutional remedies are situations in which the constitutional violation is by the state, where the arguably unconstitutional act is by the state, and there are some Supreme Court cases that say under those circumstances the state has to give a remedy. Here we're talking about a structure much more familiar to the framers than to us, in which the states and the state courts would act as a check on federal power. That is what habeas corpus in the state courts, which I think the framers clearly contemplated. That's how it would operate. That's what it would be. I think that's entirely in keeping with their understanding. And the important thing is the states didn't need to be compelled to do that. They would have independent political incentives to check the federal government, and especially the federal executive. They wouldn't have such incentives to check themselves, which is why you might need the compulsory remedies. But this isn't a state situation. This is a federal situation. Does this indict originalism? Well, it demonstrates that constitutional questions can be difficult, but I don't think so, because I think that in this case, the study of the history can show us the really big thing, and if I'm right, it shows us 2 really big things. The first really big thing, the suspension clause, is about the right and not about the remedy. Second, if I'm right specifically, it's about executive discretion. Those 2 things go a long way toward answering a lot of important questions. There are then ongoing questions under them, but I think that's a lot of work to have done by originalism. Sorry I took so long, but
I asked a lot of questions.
My first triad, and I have no Chinese criminal associations with that in my own mind, are Michael Paulson, Earl Maltz, and John McGinnis. Michael.
John, I'm not a habeas geek. But I read everything you write that I can. I'd always come at it from the other point of view, the Trevor Morrison conclusion. Let me confess how I read your paper, because it was long. I looked at the introduction, got a sense of the thesis, and you say, I'm going to have this really long section on the history, and then finally in section 3, I'm going to get to the text. So I, of course, went to the text first. It's kind of an originalist dispute. Okay, if I'm, I've always read the text this way, not knowing any of this history. Okay, if I'm a delegate at the Constitutional Convention from Pennsylvania or Connecticut, anywhere except Massachusetts, essentially, why would I understand this provision, which appears on its face to be a removal of the judicial remedy, as encompassing Massachusetts' actions in 1782, or Burke's characterization of the suspension in England in 1777? I understand that these provisions may have term of art meanings, but it just seems to me that the textual evidence leans so strongly the other way. It bothers me.
I have two quick and probably unrelated points, but I would like to say that even though I don't know anything about habeas corpus, I bow to no one in my geekiness. That first, with respect to Steve's point about originalism, I think that in this case points out why originalists are their own worst enemies. Originalism does not, properly understood, does not guarantee determinate answers. It simply is a process that asks the judge to do certain things and look at certain evidence, and only certain evidence, in order to avoid the alternative, which is make it up as you go along constitutionalism. So the fact that judges may come to different, the good faith does not indict originalism or say it's useless, because it's simply a constraining device. Other question, Abelman versus Booth. The question is, how does this, this to me is, among the many reasons I thought that Boumediene was wrong, is that it only suspended, that Congress didn't suspend the writ of habeas corpus. It only said the federal courts can't get the writ of habeas corpus. Why did that mean nobody got habeas corpus? Because of Abelman versus Booth. So my question is, I assume that if I hear John correctly, he thinks Abelman versus Booth is wrongly decided, not only because the bad guys won, or depending on who you think the bad guys are, but because it's wrong in principle. Am I right about that?
John?
Very much like the paper. Three quick points. One, I thought that this reminded me of a lot of arguments about the Fourth Amendment. The Fourth Amendment against general warrants is all about discretion, and there seems to be a consistency in that purpose. Then I have two questions. Again, someone who doesn't know much about habeas. You make a big distinction here between discretion versus non-discretion. But one can think, of course, and indeed in the modern case, Congress can give discretion to pick up terrorists, and then the executive chooses to hold some people and not hold people. And that seems to be an exercise of discretion that one might think has some of the same characteristic worries, particularly if the class of people to be held can be quite large, even if defined. The final question, and in the paper I didn't quite get, you said that it's all about focusing on Article 1, Section 8, about what is the authority to hold people in detention. I just would like you to talk a little bit more about that. I didn't quite understand, for instance, to take an extravagant hypothetical, why, if Congress has the power over the post office, there are really some big problems in the West in the post office. Rather than have a criminal law, they couldn't have detained a lot of people who were creating problems there under that theory.
Okay, first, on the question, Mike, on the question of the text. The terminology was more broadly in use than one might think. And in particular, the colonists had been subject to a statute that did this, that expanded the detention authority of the king, and that was called a suspension of the writ of habeas corpus. They had enacted a bunch of statutes like that themselves and called them suspensions of the writ of habeas corpus in talking about them. I point to the Massachusetts statute and constitutional provision because that's such a perfect example of it. You can see it right there. It's called suspension, but it says it's about the substance. But more broadly, the same terminology was in use. So it was a term of art. Habeas corpus is itself a term of art, but it was a term of art. Although not necessarily everybody would know about it, a whole lot of people would know about it precisely because they were doing this themselves. They were authorizing their governors and councils and so forth to detain people on suspicion. Earl is originalism its own worst enemy insofar as the argument in favor of originalism is, and it has certainly been made by some great men, is that it provides determinacy. No, it doesn't. So that's no. If you're an originalist and that was your reason for being an originalist, stop. You're wrong. As for Abelman against Booth, I subscribe to one of the standard revisionist positions, which is the only justification for saying that a state court can't give habeas relief against a federal officer is an implication from the federal habeas statute, that the jurisdiction it creates is implicitly exclusive. That only the Constitution doesn't do it, that only the statute may do it. Not clear the statute does it, but if you're trying to say could Abelman and similar cases even possibly be right, it would have to be for statutory reasons, because it's a premise here that there's nothing wrong under the Constitution with the state courts having habeas jurisdiction over for people who are being detained by federal officers. And indeed, one thing I say is the only obvious power that Congress does have about that is the power to create exclusive habeas jurisdiction in the federal courts, but that means the habeas jurisdiction has been switched to the federal courts. It is not, there's a conservation principle at work there. Thanks for the point about general warrants, John. Yes, I had not made that connection, but I think it's right. As for how much discretion is too much, that's one of these sort of interpretive problems about how it works that is a difficult one. And this is a situation in which I sort of find the analysis bounded on if it's true that the basic principle is anti-discretion. There are then some bounding historical examples, which are the Alien Enemies Act and detention of prisoners of war. And so I'm going to think that, assuming that the practice reflects longstanding understandings, I'm going to think that the amount of discretion that's found in those statutes, even though it's substantial, is not too much. Just because that's sort of what I'm taking from the body of the historical practice. I'm not as happy with that as I would like to be, because and if you look at the Alien Enemies Act, the president can just pick up alien enemies. But remember, everybody said back then, as to enemies, that's fine. The Aliens Friends Act, which we now call the Alien Act, is another question. What about the use of the other powers? Because a large implication of what I say is there's a really important question. Right now, here's the really important question. Can the national security powers be used to treat non-state actors the way they can be used to treat state actors? Can people who are members of al-Qaeda, whatever that means, be held indefinitely as prisoners of war? That's the big ticket item. My point is that's mainly an Article 1, Section 8 question. It's not mainly an Article 1, Section 9 question. What about the plenary, copious, sweeping, and vast, and highly discretionary postal power? I think the answer to that, I'm going to point to where the answer should come from, but I'm not sure how it works. Depends on how you understand the necessary and proper clause. Because it can't be just that it's the habeas corpus suspension clause that means that as a general matter, when Congress enacts prohibitions pursuant to its substantive authorities and the necessary and proper clause, that it's supposed to work through the criminal process. I'm not sure where that implication comes from. I don't think it comes from the suspension clause. Suspension clause isn't big enough for that. I'm gonna suspect that it comes from the necessary and proper power, but I'm not 100% satisfied on that.
Can I just make 2 brief points in response to Earl? Earl, first on the sort of Abelman-Boumediene point, I think Tarbell's more important than Abelman, because Tarbell said it's a constitutional holding, whereas Abelman Tawney sort of fudged it. And indeed, post-Abelman courts say Abelman was only about the fugitive slave issue. But that aside, in the Guantanamo cases, we actually talked, disclosure, I was one of the lawyers. On the, I don't know which side, on the non-government side. We actually talked about filing in the D.C. Superior Court. because it was a local court with common law jurisdiction over federal officers. And there's actually, I'm about to out-nerd, I think perhaps even you, there's a provision of the D.C. Code, section 16-1901B, that codifies the rule of Tarbell's case as applied to the D.C. Superior Court. No, I'm just, habeas geeks are habeas geeks. But so I actually have a short piece that no one's ever read that says the real constitutional problem in Boumediene wasn't the MCA, it was 16-1901B of the D.C. Code, which cut off the one last court that would have been left, and that you have to understand it all sort of together. So there's nerdiness for you. Let me sort of step back, though, because I don't want to get lost in the fun that is habeas nerds duking it out. I think, Earl, my point about originalism wasn't to say that it's the indeterminacy that's the problem, but that in the context of the suspension clause, there is what is to me an almost unanswerable question. And so let me try to frame it. In England, in the time leading up to the founding, there were no substantive limits on Parliament's authority to suspend habeas corpus and or to subject subjects of the realm to extra-criminal detention. The only limits were political. The only limits were whatever Parliament, where Parliament stopped or where the King stopped. The courts could sort of do everything they could when they had the power, but Parliament could impose. And so what that meant practically is that the distinction between a right and a remedy wasn't something that was an integral part of 18th century English habeas jurisprudence, because the only constraint was the authorizing statute itself. Right? Now, there's one possible exception, which is indemnification. Which is, so after you're detained, can you come back and seek indemnification? The problem is that historical sources are equivocal as to when Parliament would pass indemnification statutes after a suspension act and when they wouldn't. This is part of what Trevor and Amanda have spent 3 years fighting about in law reviews. So since the indemnification statutes are equivocal, we can't divine from the English practice a clear answer about how the English courts understood it. Along comes the suspension clause, where I agree entirely with John, and I think Halliday has it exactly right. The founders were responding specifically to the 1777 Suspension Act. And what they wanted to say is, we are going to have constraints on suspension, whatever it means. And we're going to codify it and enshrine it in the Constitution. Right? So right there we have recognizing, incorporating, and simultaneously decisively breaking from English practice by saying there is going to be a freestanding, independent constraint, even though what the constraint actually is depends on how you understand these equivocal sources that no one really had access to at the time anyway. Right? So that's the source of my sort of frustration with originalism in the context of the suspension clause, which is that it is so clear what the founders meant to do as a general proposition in the suspension clause. It is so unclear what they meant specifically because the English sources are categorically equivocal when it comes to sort of splitting the difference as to what the effect of a suspension was.
The next triad is Cy and Bernadette, and I'll complete the chord by throwing in, if I may, my own question. I guess I'll start with me. Which is this: I wonder what, if any, the significance is of the colloquial prominence of habeas among ordinary people. Both in England and in the colonies, as perhaps one of the two things, the other being trial by jury, that lay, vulgar English people and their American cousins considered the distinctive thing about English liberty as against Spanish or French tyranny and the obvious inferiority and puny slavishness of the Spanish and the French and all foreigners who begin notoriously at Calais. And the question is, did the vulgar understanding matter, and did it differ from the technical habeas geekery up to now? Cy.
So, John, I really enjoyed the paper, as I'm sure others did as well. And your presentation made me think, I think you suggested that perhaps Congress can strip away the habeas jurisdiction of state courts with respect to federal officers. And I suspect that Congress could just create, not enough inferior courts for people to meaningfully file enough petitions to get people out. So is your view that the Constitution really doesn't limit Congress's ability to choke off access to the courts? It just limits the Congress's ability to delegate discretion, and so it's a non-delegation doctrine when it comes to detention, and it has nothing to do with people's ability to go into court?
So I just have two short questions. I thought the paper was really fascinating. And the first question is really about this notion that the suspension clause is all about executive discretion, because in a way I felt like that was underplaying the increasing suspicion of legislatures that, sort of leading up to ratification that people like Gordon Wood and others have talked about, and the fact that the suspension clause is, in Article 1, Section 9, and I just was wondering if you had a more fleshed out account of, or a response to those potential critiques. And then the second point is just whether, I wasn't sure, in some of the paper, the fact that it's in cases of rebellion or invasion that suspension occurs seems to drop out a bit, and I was wondering if there's any way in which you see that as a limitation on, say, the exercise under the war powers of some kind of detention, or on an exercise under Section 8 of various forms of detention, and where that fits into your analysis.
Thank you. Myman, on the first part, I believe that although there's some divergence between the 18th century geekery and the 18th century sort of Anglo-American tradition of having contempt for people who lived under French despotism, that there was also some overlap. And that when Englishmen and Americans talked about how great habeas corpus was, they meant both that they had access to courts that would vindicate their rights of natural liberty, and because Blackstone talks about habeas in executive discretion terms too, and what is the sign of living under a despotism of someone named Louis? It is that he has arbitrary power over your liberty. So the executive not having arbitrary power over your liberty, I think, was also part of the colloquial concept of habeas corpus. As the jurisdictional stuff is the stuff I have less confidence in. So I'll say that here I am less certain, and that's a good question. If you think that, as I do, that it is a necessary condition for Congress to eliminate the jurisdiction of the state courts in a situation like this, that it create corresponding jurisdiction in the federal courts, because what you think Congress has is, by the combination of Article 3 and the necessary and proper power, the power to make federal jurisdiction exclusive, that's the primary thing, and that's what's authorizing them to do the Abelman against Booth, Tarbell's case kind of thing by statute. Does that mean that to some extent Congress has to, practically speaking, give enough federal jurisdiction for it to be meaningful? I haven't thought that through. I think the answer may well be yes, because the predicate for the bar on state court jurisdiction is making the federal jurisdiction exclusive. If there's no federal jurisdiction, it's not being made exclusive. So there may be some requirement that there be some substantial amount of federal jurisdiction to be there, so that it can support the exclusion of the exclusion of the states. Probably, but I'm less certain on that. Bernadette, on the first point about fear of legislatures, two things. The specific thing about suspension, I think, was fear of the executive, particularly. There were a lot of things that people were afraid of in legislatures in those days. One thing to bear in mind is, I think this is true, that the federal convention thought they had two solutions to the problems of the dangers of legislatures. One, at the national level, was to create the big compound republic and constitute its legislative power the way they constituted it, so it wouldn't run amok and do things, and to give it only enumerated power. And in responding to the people who were, like many of them, who were concerned about legislative power at the state level, to do things like the Contracts Clause, other affirmative limitations in Article 1, Section 9, but that most of the things they did to make sure that Congress wouldn't behave like a demagogic state legislature, they did through the structure, by setting Congress up so it wouldn't be, large districts, the whole Madisonian thing, so it wouldn't be occupied by demagogues. Rebellion and invasion. rebellion and invasion make permissible the grant of untrammeled discretion to the executive to detain people for national security reasons. In the absence of rebellion or invasion, my view is whatever the war power authorizes that's not broad discretion in the president is okay as long as it's authorized by one of the enumerated powers. I'm mainly talking about the war powers, and doesn't go so far into discretion as to contradict the suspension clause unless there's been rebellion or invasion. So yes, there is some substantial room for additional detention authority, and as I say, I think the crucial question is how far do the enumerated powers go?
But so then, can I push back on that for a second? So if Congress were to hypothetically pass a statute that says the president is empowered to use all necessary and appropriate force against those persons he believed planned, committed, perpetrated, you know where this question's going?
Absolutely, I know the answer.
Okay.
That's a real problem.
So the AUMF is unconstitutional because it violates what provision?
To the extent that it authorizes detention, the AUMF, if it really does, and this is something I need to think about a little bit more, but it raises a really serious suspension clause problem because of the part that says who he determines. When Congress in a declaration of war says who the enemy is, that's fine. To get back to John McGinnis's question, that's what I'm taking as one of the bounds set by the practice, that the authorization of holding enemy combatants and enemy aliens in time of war is not suspension because it's determinate. It's determinate because Congress says who the enemy is. There's a really good question whether the part of the AUMF that says whoever the president judges, not Al-Qaeda or not who did this, but whoever the president judges did this, whether that is too much discretion. I'm not, when I say I know the answer, I know the direction the answer goes. It may be, I'm not certain whether it is, because it's a tricky question. It's a tricky question with the old suspensions where you have the structure where he's given an instruction but he's told to apply it himself. Whether that's too much discretion, but there's a real suspension clause problem with the AUMF because of that part of the authorization for the use of military force. The people he determines did it. Yes.
The next question, which will be interesting to hear whether it is couched in language or otherwise, is from Stanley.
Well, I wanted to say first that I agree entirely with John Harrison, and Earl Maltz, that originalism is not undermined because it doesn't provide answers. And in fact, the idea that originalism might be undermined because it doesn't provide answers is what I would call vulgar originalism. Originalism is the main thesis in originalism is the question of what is being sought, and the truth of originalism doesn't depend on whether what is being sought is actually found. So that the fact that you haven't found what originalism seeks is not an indictment of it. It's just a testimony to the fact that originalism, the seeking of what some intenders had in mind, can fail. And since interpretation, at least in my view, is not a theoretical but an empirical task, and since we know that one thing about empirical efforts is that they can fail, there is absolutely nothing to conclude from the fact that there are sometimes equivocal sources or unequivocal sources. Equivocal and unequivocal do not bear at all on the originalist, intentionalist thesis.
Will Dowling.
So my question is, by the end of the paper, I guess in an attempt to reconcile the history with the text, you start saying that you can say that a remedial legal advantage has been suspended once the substantive principles have been made inoperative. That's the way you can see this, the way you can square this idea with the habeas clause is that. And my question is, does that mean that we should believe in substantive due process too? Because there's another clause that guarantees a procedural right, and there are plenty of cases where the legislature attempts to, rather than suspend the procedural right that it can't suspend, it just eliminates the whole substantive category altogether. That makes the procedural right meaningless in the same way that these suspensions make the habeas right meaningless. So does that mean we believe in substantive due process too, and if not, why not?
first to Stanley Fish, yes, absolutely. And I will add, I think that what one thinks about this, although I'm a textualist, I think that the textualist-intentionalist distinction, I don't think a textualist or an intentionalist would think any differently on this question, because I think everything I say about the meaning of the suspension clause can perhaps even more readily be put in terms of what people had in mind when they drafted and ratified it, and indeed, as I say, even more readily because, remember, they had been subject to a suspension and they had suspended, so they had this much in mind. Well, yes and no. The first part is that remember what I'm doing in that part is trying to understand how the terminology could develop and how you could come to talk in terms that sound like you're talking about the remedy when you're talking about the right. And the suggestion is, well, if you think that the remedial proceeding would then become pointless, then you might, because the power over the right had become so large, you might say, yeah, and that's kind of like getting rid of the remedy, because what's the point if you're not going to be able to prevail in it? Does that then mean? And excellent question, because there's a standard back and forth, and what I say about the habeas remedy and the right of natural liberty is a particular manifestation of this larger structure, where there's a protection of procedure, and somebody says, but of course it's only a protection of procedure, and as long as the lawmaker has complete power over the substance of whatever the entitlement is, then the protection of procedure can still be in place. And I think this is absolutely true with respect to habeas and natural liberty. The protection of procedure can be completely left in place, and nevertheless not really matter very much because of the change in the right. And that is then an argument in favor of substantive due process, because the argument is, well, it can't be, and this is when those cases that John Bingham was talking about, when he said the courts have decided what procedural due process is, what due process means, and you can go and look it up. Some of those cases were what we would call proto-substantive due process, and part of the reasoning that they were engaging in was, and there are later cases shortly after the 14th Amendment in which a couple justices say this, well, it can't be that the point of the procedural protection is only procedural, because then it could be defeated by a change in the substance, and so it's possible to infer from a procedural protection that there's going to be substantive protection. I think that my argument about the evolution of the usage certainly shows that it's common to see the connection between substance and procedure, and how the importance of procedure comes from substance. That is right. I don't think that implies that it's senseless to have purely procedural protections, which is really what this version of the substantive due process argument is saying. Because if you think that there are, for example, political constraints on what's going to be done with the substance, but you're concerned about somebody, which branch of government, not entirely clear, screwing around with the procedure, you might well want an independent protection for the procedure. So yes, this is a cousin of that particular argument for substantive due process, but I don't think, in fact, it logically entails it.
I think Stanley's point was directed more at me than at John, and so I thought I don't disagree. I mean, I think, just to be clear, that in INS versus St. Cyr, the Supreme Court said the suspension clause at a minimum protects the writ as it existed in 1789. Right, so the Supreme Court has suggested that the jumping-off point for understanding what the suspension clause means is the scope of the writ as of 1789. My only sort of thought on this is not that originalism doesn't teach us valuable lessons in this context, but that it doesn't actually do what the court wants it to do, right? And so the reason why it doesn't do that is because John and Amanda Tyler and Justice Scalia have this substantive view. Trevor Morrison, myself, Eric Friedman have the remedial view. This is a fairly significant methodological fight that I think has evidence on both sides that reasonable people can defend. And so, barring some thought that one camp is clearly right and the other camp is clearly wrong, I think it's the Supreme Court that's on a bit of a fool's errand in saying we can have this understanding of the writ as it existed in 1789 without actually accepting that we have to pick a side, right, without actually getting into the middle of this fight. And so, no, Stanley, I don't mean to suggest that we can't learn a lot from the sources. I think my point is that without some conception of what those sources actually tell us about how habeas was understood, the Supreme Court is kidding itself.
On related to that, this is one of the things I thought about raising at the outset and did not, but I do want to bring it up because it's interesting enough. One of the other aspects of the substantive understanding of the, and I think our difference is not methodological. I think it's interpretive. It's which one does it mean? But I think one of the interesting issues that's raised by the it's about the right, not about the remedy concept is, as Steve's saying, the habeas corpus remedy has continued to change since 1789. What the Supreme Court said in St. Cyr is, we're not sure whether habeas is an inherently dynamic concept that refers to this legal phenomenon right now as opposed to in 1789, but it's at least 1789. That's what they're getting at in St. Cyr. On the other side, there is the substantive conception. And one accident of history with the fact that habeas didn't actually get suspended in the United States until 1863 is the substantive understanding largely got lost. And so it doesn't have one of these subsequent histories the way the remedy does. And so that's another reason you might think, just kind of by accident, on this issue, you have to be an originalist, because even if you believe in subsequent development and evolution, here there hasn't been any.
Well, except, I think one could argue that the 14th Amendment and the Habeas Corpus Act of 1867 reflected a slightly different view of the purpose of habeas, but that's just my crazy remedial
Well, not a view of habeas, but not the concept of suspension of the privilege of the writ of habeas.
That's
Habeas, absolutely. It's important. I don't want to say anything against the great writ. It's a great writ.
Let me, Richard Nixon famously said of the Great Wall of China that it certainly is a great wall. Let me move on to the next triad. The Chinese theme keeps reappearing, which is Don Drift, Steve Smith, and Cy as a recidivist. Don.
I want to pick up on Stephen's comment, which is a lot of the constitutional provisions assume or expect continuity to common law. They don't instantiate the common law, and statutes trump common law. So when we say that Congress couldn't abolish the writ of habeas corpus, why is it that they couldn't? The suspension clause says suspend. It doesn't say must maintain or there is such a right. When this shows up all the time in the Fourth Amendment, like the state trespass actions, which are the assumed remedy, but if those atrophy, what does that tell us about the expectation? So basically the problem is that the background is common law, which can be trumped by subsequent statutes, which they knew, but they assume that the common law, what other baseline could they use, but they don't instantiate it. So what subset of the common law background is constitutionally instantiated? What subset is not? And do we have any criteria for choosing that?
Steve.
Okay, well, my question, I should say, first of all, I really enjoyed reading the paper. It was an area totally unfamiliar to me, and my question sort of reflects the difficulty that I had when I first started reading it, because I had a hard time grasping the significance of the distinction that's crucial to the paper, and I wonder if there's something in that. So it seems like both, what I take it is the long-standing view in this country that you used to hold, I think you say, but that you're now criticizing, and the more revisionist view that you're advocating now, depend upon the notion that there is a pretty significant distinction between substantive rights and remedies, and so then the disagreement is over which of those was the subject of the suspension clause. But of course, somebody can. There are those who either through maybe obtuseness is in my initial reaction to it, or more deliberately doubt that there is a significant distinction there. You can think of, I think, Holmesian or legal realist views of it, say, it's meaningless to talk about a right except, in terms of a remedy. But that, I think, is not only sort of 20th century, skeptical view, if I remember correctly, and this goes back almost as far back as the history that you're talking about here, but when I took a legal history class from SFC Milsom, in law school, him stressing over and over again that we often misunderstand history because we keep imposing our concepts and distinctions on them, and they didn't understand there to be a difference between the writ that you were entitled to and some substantive right that it was protected. It was pretty much procedural the way. Now I think he was maybe talking about a little earlier period than you're talking about, so maybe understandings had changed by that point. But at least to this question, do both of the positions, the position you held and the position you're now advocating, depend upon the idea that whether you're thinking about the framers or the public understanding, that it was accepted that there was a significant difference between right and remedy, even though they're connected, there are connections between them, and if it turned out to be not the case that was a generally accepted, meaningful distinction, what difference would that make? In one way, it did occur to me that would help you in the section of the paper where you're responding to like Mike Paulson's question and talking about how even though the language sounds very much procedural, it could have had this other meaning. But in terms of other implications for like current controversies, where would you go with that? The whole argument hinges on a distinction that maybe at the time wasn't a viable. I'm not saying that it was or wasn't, but do you need to depend on the assumption that it was a viable distinction?
I have at this point quite a few first offenders, so can I come back to
Yeah,
the side?
of course.
David.
Quick question. If the suspension clause provides the authority for authorizing detention without trial, would it authorize detention with trial? In other words, was the Milligan majority wrong to say that Congress could not constitutionally authorize a military trial when the writ was suspended? Because the writ was suspended at that point in time.
Okay, on Don's question, I think that's actually more a question for Steve than for me. My answer is common law rights are subject to limitation by the national government to the extent that it's authorized by an enumerated power, and it's not limited by an affirmative limitation like the suspension clause. So I have no dog in that hunt. Steve, I am standing for the distinction between rights and remedies, and I don't deny the importance of the fundamental legal realist insight. But on the other hand, Hart and Sachs in the legal process point to that statement by Holmes and say they're very bad, and that's reasoning backwards, and you got to reason frontwards, and reasoning frontwards means reasoning from substance to remedy, and not from remedy back to substance. I will point to something historically. The label of distinguishing between right and remedy certainly used in the 18th century. Point number one, a demonstration of the importance of the distinction and an operational way in which the distinction was absolutely on display in the 18th century. Habeas corpus could be used. Think of Somerset. Habeas corpus could be used to test the detention of somebody as a slave. Slave states and free states, and as it turns out, said Lord Mansfield, free countries like England, both had the same remedial apparatus of habeas corpus. Whether the person was remanded to custody or not depended on the substance of the law of slavery and bondage, whether it was a slave state or a free state to begin with. So that's a situation in which the same remedy and habeas, the one I'm talking about, takes different substantive inputs and gives different substantive outputs. So I'm reasonably confident that despite the importance of the writ system, despite everybody's tendency to reason backwards, that then as now it's possible and important to reason frontwards. As for Milligan, I'm not sure, but that's because I think the answer to the question concerning congressional power there depends not primarily on the suspension clause, but it's mainly the quirine question. It's the interaction between the war powers, or in that case actually the power to put down rebellions being used in warlike fashion, like by taking prizes, for instance, the interaction between that and Article 3 and the jury trial right, for example. And I'm not sure how those work together, but that's another one of those situations where I think the key question is elsewhere, and there the key question is partly in the powers and partly in other affirmative limitations.
Although it might be that Davis stumbled into a really, really strong argument for you, which is that if the suspension clause is substantive, perhaps it is there, as opposed to the other places where people have tried to find it, that the power to impose martial law can be found. Right?
I'm going to have to resist that temptation because, again, it's in Article 1, Section 9 and not in Section 8. So the powers have to come from somewhere else. It can confirm the existence of a power, but it can't really create it.
Let me just quickly respond to Don because his question, I think, is still pending. If one accepts the remedial view, John doesn't anymore, I very much do, then what the suspension clause does do is it ensures that the remedy is protected in some form, in some forum. Right? And indeed, the Supreme Court has said, not just in Boumediene, that the suspension clause requires habeas or a constitutionally adequate substitute. And so Congress, of course, is free to replace and supplant habeas with something that is adequate or more than adequate. But the point becomes that Congress cannot go below the constitutional minimum, which is, according to the Supreme Court, what was true in 1789. This may sound esoteric, but in England, in fact, all of the habeas corpus acts, especially the Habeas Corpus Act of 1679, existed side by side with common law authority at the same time. And indeed today, when the D.C. District Court is resolving a Guantanamo habeas petition today, the source of their jurisdiction is not a statute. Now, you might say it's the Constitution, but I think to that extent the Constitution is codifying or enshrining common law.
There are several more first offenders and recidivists on my list, but I have been, and the first of them is Mike Rappaport, but I was told that I have some discretion as moderator, but no discretion whatsoever as to when the session ends, and this I was told by none other than Mike Rappaport.
No one is the judge in his own case.
So, without being able, therefore, and purely by the disabling act of Comrade Rappaport, to go to him or to what we at San Diego call, respectively, the other two people on the list, Low-Tech Larry and High-Tech Larry, both of whom will have to be pending. This has been spectacular, and great thanks to John and to Stephen. Thank you very much.